There's no possibility of getting the preliminary injunction because you can never show irreparable harm. Is it redressable?
It's redressable because you have to accept the party's allegations and merits arguments for purposes of assessing standing, even if ultimately those arguments turn out to be incorrect.
Let me ask you this. Wonder why, follow up on Justice Kagan, curious that the government didn't want to touch the chill theory. Might there, if the court were to adopt the chill theory or reject it, would it have an effect on federal litigation? Is it Reisman and Claire Furness don't really address a chill theory, and I wonder whether in federal litigation an abuse of subpoena seeking to chill First Amendment rights could be challenged, or whether under your view you have to wait till the end of the case.
The chill theory would not affect federal litigation because the chill theory goes to Article 3, and our objections to the pre-enforcement suits in federal litigation involve the existence of a cause of action.
A remedy at law. But if the only remedy at law is waiting till the end of the case, and the chill will have been manifested before then by having, say, to disclose your lists of donors, I would have thought that equity could step in there, no?
There are narrow circumstances in which ultra vires review in equity would be available, even with respect to federal subpoenas. But as the court said in its Nuclear Regulatory Commission decision last term, the standards for that are quite high, and it would be a very narrow exception. But if we don't have concerns with adopting a chill theory so long as the court says that a credible threat
you're not suggesting that the federal government has more ability to not just chill but to infringe upon the First Amendment than states do?
No.
Okay.
I'm suggesting only that Congress has made different decisions about what types of causes of action to provide.
I understand that, but if the cause of action is inadequate because it comes at the end of the case after the damage has been done, surely the government can't take the view that the First Amendment has no opportunity to step in and those arguments to be presented.
No, that's a good argument to make to Congress for creating new causes of action.
To Congress.
To Congress, yes.
Yeah.
This court doesn't have the authority.
So somebody who faces an abusive subpoena by the United States government has to go ask for Congress to change the law.
No, as I've mentioned, there is a narrow exception under ultra vires review, but in general, the ability to challenge it in federal court comes at the end of.
Why would it have to be ultra vires? Reisman and Reisman and Claire Furness talk about the adequacy of a remedy at law as being the point. And if there isn't a remedy at law, it says equity can step in.
Ultra vires review is merely another term for the same equitable action that.
Okay, you're saying it's the same thing.
It's the same thing.
All right.
Thank you, counsel. Justice Thomas? Mrs. Kagan?
We made clear that the ultra vires review is really close to non-existent.
Exactly right. Yes.
Okay.
It is very narrow, but it is theoretically available in some extreme circumstances. Yes.
You have an example?
Liederman Kine is the one that comes to mind. That was a long time ago.
How about where the First Amendment is being violated?
I gather that's not good enough.
No, because in most cases, the opportunity to get a federal court to adjudicate the lawfulness of the federal subpoena is provided at the end of the subpoena enforcement process. And therefore, there isn't the same question as arises in this case about losing the federal forum entirely.